Morning.
Good morning.
Mr. Gordon?
May it please the court, I'm Joshua Gordon. I represent Evelyn Tarnawa, and her health prevented her from being here this morning. Stella, the mother, her will was settled by summary administration. It was uncontested. The sister and brother, the parties here, stipulated on the standard form to no outstanding, unpaid, or unresolved debts, obligations, or claim, and the case closed. And that was in 2010 or 11. Their dispute, the current dispute, arose long after the probate was done. It was when Evelyn learned that Richard hadn't paid the taxes and that he had misled her for years. And while prescient lawyers might have anticipated that there would be this sort of instability in the future, Evelyn lives in Connecticut, and it didn't ripen into a dispute until she got a $35,000 phone call from the tax collector. There is concurrent jurisdiction in both the probate court and the superior court. And that's because Evelyn's partition action, and it's a partition action, is not related to any pending matter before she filed it in any court.
Well,
It's
Ms.
not related
Nixon,
to the estate, it's just because the legislature has seen fit to grant partition jurisdiction to the probate courts.
Yes, right. There's concurrent jurisdiction, and this court has been very careful to constrain the probate court side of that within its statutory bounds, and has defined this, and most recently in Rogers, which is decided this year, that there has to be a direct connection to probate. And Rogers explains that direct connection, there must be a direct connection between the claim, Tarnawa's claim, and the composition, administration, sale, settlement, or final distribution of the estate, and in a manner which mandates the probate court's exclusive jurisdiction. So when there's shared jurisdiction or concurrent jurisdiction, the partition action has to really be, it can't just be genesis in a probate estate, it has to be related to interpretation and construction of the will.
What about Ms. Nixon's argument that this would all make sense if you'd filed a partition action, but that isn't what was filed?
That's what was filed. It asked for partition.
But it was a contract claim. One of the requests for relief was partition. Is that accurate?
I think so. And the contract is just irrelevant. Whether there was a contract or not, an owner has a right to partition at any time, and that law is
Whether they're a joint tenant or a tenant in common.
And it doesn't matter what kind, whether you're tenant in common or joint tenant, it really doesn't matter. The contract doesn't matter. Ms. Tarnawa has a right to partition, and she has a right to partition whenever she wants to. And so the laches argument goes away. The res judicata argument goes away because there wasn't any dispute back then. And there was jurisdiction in the superior court. So I think, well, turning to the equities of it, the court handled them all. You can't split a small house, right? So you have to divide ownership somehow. Evelyn delayed taking the value of her inheritance for a decade as a kindness to her brother, providing him free housing. Richard reciprocated by causing her a $35,000 surprise debt, and she is now beyond wanting to settle for any sort of middle ground like a life estate.
Well, but the evidence is that Richard asked his sister to pay her share of the taxes, and she refused, right?
There was evidence that he asked her to pay an insurance, something related to insurance, and she paid that once. But she didn't know that the taxes hadn't been paid. The phone call from the city tax clerk was a surprise to her, and she had assumed, based on some sort of informal understanding, that he was going to live there and paying the carrying costs while she forbore from foreclosing.
In fact, her attorney outlined that understanding in a settlement agreement that was not eventually signed.
Correct, but
Right.
that whole record of correspondence makes it clear, and the final one where Attorney Hawthorne wrote to Mr. Goode, just stay there, and, just stay there and stay there as long as you can, because we reached an impasse here. And the impasse was, well, Ms. Tarnawa is in Connecticut living her life, and Mr. Goode is living in the house and paying for it, presumably. Ms. Tarnawa is past wanting some sort of middle ground, like a life estate. First of all, she just wants to be out, right? And she has a history with her brother. He borrowed money from her, didn't pay it. She learned during this litigation that she had forged their mother's name on registration for a decade. And the way the court resolved it was to split the taxes, because both parties are liable for taxes, so it's fair that the parties split them. I didn't cross-appeal that issue because, well, it's probably fair that they get split. As to the penalties, Ms. Tarnawa, just like the Superior Court said, Mr. Goode robbed Evelyn of her opportunity to pay the taxes herself or take action to mitigate the damages. And therefore, it's equitable that Goode pays the penalty, and this court should affirm.
Can you help me with the provision of the will, and I think it's paragraph 4th, that mentions, it looks to me like it's a typical devise which would not extend beyond Stella's death, but simply awards her property to either surviving sibling. So can you help me with where this idea comes from, that post-death the will would, Stella's will, would control if one of the two siblings died, the other would take completely, or is that just arising from the joint tenancy?
The will says they take in equal shares, quote unquote, in equal shares.
Except as long as they survive her, and if she's survived by only one, then the will devises to the one.
Yeah,
So it's a typical, there's no,
Typical.
and after I'm dead, when one of them dies, the other gets it.
right.
Okay.
Exactly how that's structured, I don't think it matters very much, because one way or the other, they are joint tenants, and there is a right of a
But there's
joint...
no prohibition on one of the joint tenants trying to encumber, sell, or partition their share.
Correct. It's just you have a right to partition at any time, and this is when Ms. Tarnawa chose to do that, when she got a call from the tax collector. Thank you very much.
Thank you. Case submitted. I ask the parties please to